Hello everyone, good morning, good afternoon, good evening, depending on where and when you're joining us. Welcome to the ESTB Interview, the program that brings to you the key actors of the tax world, the people and institutions that make this field move. Taxation is made of rules, but also and above all of people. Understanding who these people are and how they influence the tax system is essential to grasp the dynamics of this field. With this premise, the Escola Superior de Tributação de Brasília, ESTB, has created the ESTB Interview, a space of dialogue with leading figures where we explore their trajectories, ideas, and contributions to the future of taxation. Today, we turn to one of the most technically complex and conceptually delicate questions in international taxation, which is the compatibility between the global minimum tax rule, the so-called global rules, and the existing networks of tax treaties. In his recently published chapter, Global Minimum Taxation and Tax Treaties, released as part of the IBFD Global Tax Treaty Commentaries, our guest examines how Pillar 2, through the IIR, the QDMTT and UTPR, interacts with, challenges, or departs from established treaty principles, including taxing rights allocation, nexus, and economic allegiancy. His work offers one of the clearest analyses currently available on where the global rules align with the tax treaty framework, where they diverge, and what this means for the future of the international tax order. Our guest today is Dr. Alessandro Turina, Principal Associate at the IBFD Academic Department, where he also serves as Managing Editor of International Tax Studies and contributor to the Observatory on the Protection of Taxpayers' Rights. He holds a LLM in International Tax from the University of Michigan and a PhD in International Economic Law from Bocconi University in Milan. Dr. Turina is a lecturer at Bocconi University and a visiting lecturer at the University of Freiburg in Switzerland. Throughout his career, he has held visiting research and teaching positions at institutions including the Vienna University of Economics and Business, the Oxford University, Georgetown University, the University of Florida, and the University of Lausanne Tax Policy Center. He's also a member of the IFA, the Italian branch of International Fiscal Association, and has published extensively in the field of international taxation, including his latest contribution on global minimum taxation and tax treaties for the IBFD Global Tax Treaty Commentaries. Dr. Turina, thank you very much indeed for joining us today. It's a real pleasure and an honor for us to have you here.
Good morning or good afternoon. The pleasure and honor is really mine. Thank you for having me.
Thank you, Professor. Well, as always, to begin, we would like to explore a little bit your personal information on the tax field. So could you share with us a little bit about your professional journey? How did you first become interested in international tax law? So we want to know your first steps in international tax fields, and what led you to specialize in the intersection between tax treaties, global minimum taxation, and the broader architecture of the international tax system?
Thank you very much. A long story, but I'll try to keep it short. So I had all of my, let's say, undergraduate graduate training at Bocconi, besides the LLM from Michigan, and Bocconi is originally primarily a business school. So I've always thought that I would deal with business law in some respects, maybe corporate law, commercial law, and eventually I applied for this PhD in international economic law. So my first interest was, in fact, what is very topical today, trade and investment disputes, and there I sort of discovered international tax as a bit of a neglected area within the broader framework of international economic law, and I took it from there essentially, and I had the chance to meet great professors who inspire me, and I keep this interest in international tax, trying to place it within this broader framework of international economic law that I would say is my main approach to the topic and to the field.
Great, Professor. So going directly to your article. Your chapter begins by noting that the globe rules were drafted without fully engaging with the interaction between Pillar 2 and tax treaties. Could you explain why this gap exists, and what motivated you to analyze treaty compatibility in so extensively?
Yes, thank you. I think that's really the key question, because indeed, if we look through the let's say, the evolution of the international recommendations surrounding Pillar 2, and in particular the globe rules, we noted that the issue has been always somewhat neglected. It could even be argued that perhaps there was more on the point in the original blueprint document, that also contemplated, among other things, a switchover rule, which I trust would have been helpful in addressing some of the issues we're going to see. But eventually, this switchover rule was also dropped. So whenever something is not said, typically, the question is if there is silence on a topic, is it just to go back to the roots, to Roman law brokers, perhaps come to succor. So ubi lex voluit dixit, ubi noluit taquit. And okay, if it didn't address the issue, why this is the case? And of course, we know these rules are not born in a vacuum. They are of course, they are technical pieces of technical legislation, but they also reflect consensus or dissent, perhaps. So is this silence expression of a consensus, or perhaps do they betray some some unease? And at the same time, especially in the, I would say, ancillary documents that can be very helpful for interpretation, from the commentary, but also the administrative guidance, whose legal status is also quite a big question mark. There are indeed some references to how a certain issue would not create a friction with the tax treaties, but again, to build on old Roman law brochards, one may raise the point excusatio non petita, accusatio manifesta. So basically, whenever you say that something is not an issue, and you try to excuse yourself in a way, then perhaps an issue may be around the corner. So I thought this could be interesting to investigate, and I have to thank my colleagues really to getting me on board with the topic. Two main steps, I would say, in my trajectory in this area, when I was working in Lausanne with my esteemed colleague and friend, Professor Chand, together with doctoral candidate of his at the time, we wrote a piece essentially addressing these very aspects, focusing in particular on also the interaction with the arm's length standard. Our, let's say, results were published on the World Tax Journal almost now 4 years ago. And then at IBFD, I was involved in editing what is, to the best of my knowledge, it was the first, let's say, collected work on essays, let's say, collect essays on Pillar 2, and in particular, at the time, the blueprint had just been released. So, of course, in a way, a lot of time has passed. We have the model rules now, we have the commentary, the series of administrative guidances. But let's say I had this early interest in the topic, and I just tried to let's say, match this interest in Pillar 2 with the more traditional field of treaties. In the meanwhile, of course, I guess the issue is quite one that is very evident, also intuitive to some extent. So a lot of great literature on the topic has been produced, and basically try to, also given the nature of the chapter that is, if you want, well, as the title of the collection suggests, is essentially meant as a commentary. Here, it couldn't be a commentary to the actual model rules or a meta commentary to the model rules, but what it tried to do is essentially to go article by article, so to follow essentially the ESTB model as a template, going article by article and trying to find what is the interaction between, let's say, the globe rules in particular and the specific provisions. And so that helped me to also consider aspects that I perhaps neglected, or I thought maybe were not really an issue. And indeed, several issues came to the fore, even though always I would say, like in any good story, I know when you have a movie, you have the ending that leaves the question open, and I would say here it's a bit the same. So lots of questions, but I would say still a bit open questions.
I see. You've mentioned something which is very important for us at the ESTB. All discussions concerning technicality are built over a political layer. So it's important always to remember that everything that has been discussed so far is based on what was the consensus of the main actors in the field at the time. So it's important for us to remark that. But going back to the technicalities, which is our interest today, you highlight the potential conflict created when the methodologies concerning the global rules, namely the IIR, the QDMTT, and the UTPR, allows a jurisdiction to tax income that a tax treaty allocates to another state based on applicable distributive rules. So, based on this premise, in your view, how serious is this incompatibility, and how do tax treaties conceptually restrain or hypothetically restrain the application of Pillar 2?
Well, in fact, I would say that the answer to this question is already contained in this very insightful question, because as you point out, essentially these globe rules may tax, by virtue of their operation, income that has been allocated under the allocation rules provided in tax treaties to another jurisdiction. So there is, I think, hypothetically, there is almost bottomless room, for if not necessarily for friction, let's say for issues to be discussed. Of course, as such, the amount that corresponds to the QDMTT, sorry, to the IIR or the UTPR, or eventually also the QDMTT that are levied is not, let's say, income. No, it's we're talking about the tax, but of course the question is where does the base, let's say, to which this tax apply come from? And of course, that's a very complex question, because we know the determination of the globe base is one of the most, I'd say, complicated, complex technical issue within these rules. So, to put it simply, we have to check whenever there may be a mismatch between what basically the tax treaty would say in terms of allocation rules and what eventually let's say the globe rules achieve through their very operation. So it may be taxed elsewhere, let's say in a state that is not granted, in a jurisdiction that is not granted taxing rights under the tax treaty. Or also we should not forget that, of course, there is also I think the jurisdiction to tax, and this applies also under tax treaties. It's of course the jurisdiction to tax, but also the jurisdiction not to tax. So basically, a jurisdiction may have the right and sometimes the obligation not to tax something, not to tax a certain item of income, and then because of the operation of the rule that we are discussing, the globe rules, it may be essentially required to do so. So I think there are plenty of issues. Of course, the area that perhaps comes to mind most obviously is the area, also because it's maybe the most important one, is the area of business profits, and where I think the allocation rules are, of course, complex to apply, but quite clear. And then we can have many different articulations depending on whether we're applying the IIR or the UTPR, and essentially also whether, in the case we have, for instance, a PE, of course, what is the fact that, of course, maybe there is income that can be attributed to the PE based on the treaty, so the PE state can tax, but then, of course, the state of the head office can also tax, but at that point in time, elimination of double taxation needs to be applied by the resident state, and as such, the state, let's say, of the home office. And of course, depending on whether we have a credit or an exemption we applied as the method, we may have, let's say, different outcomes. So, of course, this is also always linked, let's say, with rules that govern the elimination of double taxation. So, essentially, Article 23, either under A or B, so depending on whether you apply the exemption or the credit method. And then, of course, we could do, and that's basically what the chapter tries to do, not to go basically provision by provision or model provision by model provision, following the OECD model as a sort of a template. We didn't, let's say, focus on specific treaty provisions in specific treaties because this is, well, we have within the structure, let's say, of the global tax treaty commentaries architecture, there is another segment called Pillar 2, but it has nothing to do with Pillar 2. It's like a second portion of the collection that deals with the treaty practice of the various states. So I essentially relied on treaty models, OECD and UN as well as the template. And I would say Article 7 is a very clear area where a potential friction may emerge for the reasons we just addressed, we just discussed, but also, for instance, Article 6 on immovable property may also raise some issues. Article 8, of course, there is on international traffic now with the fact that shipping essentially does not really fall within the purview of the globe rule, so that sort of mitigates, let's say, the potential problems and so on. One of the other areas that would be very interesting, and I would say it's still a very nuanced issue, and there are, in the literature, there are differing views. I have to disclose this, is in fact, again, what is the relationship between globe rules and the arm's length standard? In a way, if you look at the, let's say, all the context to the globe model rules, the commentary, etc. Essentially, it's clear that the globe rules presuppose the arm's length standard, but still, let's say, there may be some points of potential friction, and as such, it's and again, what about the possible economic double taxation that may arise? So not only Article 9, Paragraph 1, but also Article 9, Paragraph 2, which is a very tricky provision within, let's say, the model, because as we will see, essentially the possible way out to a lot of the conflicts that we discussed may not be applicable to this provision, Article 9, Paragraph 2, essentially because it's typically carved out of the scope of application of the so-called saving clause. So for the time being, I think it's this discussion, let's say, that we are having carves out the operation of the saving clause, and which of course is there, but maybe not as concrete, as we may, given the current status of the international treaty network.
I see, Professor. I was concentrating on your arguments, and I cannot ignore the fact that this is a very controversial subject in the international tax field, and I have been reading some arguments justifying Pillar 2 by analogy with CFC rules, which is the OECD's argument on that. On the other hand, your article stresses that this analogy with the CFC rules is weak and potentially misleading. So my question is, what are the decisive differences between the IIR, for instance, and the traditional CFC regimes? And why can't the CFC analogy, this argument of CFC analogy, be used to claim the treaty compatibility?
Well, I think it's a very crucial question. So I in a way, of course, it's also because, of course, once you find a potential friction, it doesn't mean that it cannot be resolved, no, or justified. I hinted to something within, let's say, the treaty, the current, at least, version of the OECD models in 2017, so namely the saving clause, but in fact the very saving clause now has been used to, let's say, also corroborate essentially the compatibility of tax treaties with CFC rules, and of course that compatibility is not in my mind, but I guess, let's say, it's something that on which we can of which we have to take note. Now, in light of case law by various courts worldwide, it's not something that we can take as we can take for granted. But I would say there is at least a fundamental difference, no, between CFC rules and GLOBE rules, essentially because, of course, it's not in terms of their very object and purpose, or rationale, also on the policy plane. So, well, the CFC rules, and here we have to take into consideration a bit of a transatlantic divide as well, and transatlantic, where I would like to say maybe northern transatlantic, because of course also Brazil and Latin America and Europe are separate. So whenever, but let's say the north. Well, maybe we could also fit Brazil in the discussion because it's a very interesting case. But typically, the idea, that to summarize, that of course the CFC legislation is essentially something that was originally developed in the US, and Subpart F, and the original intent to use the, let's say, US term of art, was essentially to prevent deferral, at the time. In the European experience, also in light of the developments that we observed that through negative integrations of the case law of the Court of Justice, and well, now we also have a directive that basically delineates what are the, let's say, the blueprint, let's say, for adopting CFC legislation in the member states. Essentially, what we see that it's not it's a no-go area essentially to divorce CFC legislation from an anti-abuse function. Now, it's the question is are GLOBE rules about deferral? Well, that would be another issue, but I would say more interestingly, perhaps, are GLOBE rules about abuse? And the answer, to the best of understanding, is that's not really the case. Of course, it's a very complex question, and with many ramifications. What is the purpose? What is the rationale of GLOBE rules? Interesting again, so whenever we talk about eloquent silence, so there is nowhere really, like, in terms of a potential preamble, or even in the commentary, you don't find let's say any decisive material that could be used to interpret what is the the object and purpose of these rules. You find some interesting references in the administrative guidance, and it's clearly based on that guidance, but essentially a system meant to prevent the race to the bottom. So a sort of a mechanism to address tax competition, going back perhaps a sort of eternal return or cycle and counter cycles to the original harmful tax competition project, but focusing essentially on rates, and of course not only on rates but also on the system, let's say, of incentives. And also there is in fact a sort of regulatory intent as well there, and of course all of this is absent from CFC legislation, and it's in a way this is something that also percolates through the application of the rules. Then, with regard to the more technical plane of the mechanics of the rules, one of the arguments that is often made to basically argue that essentially CFC rules do not pose compatibility issues with tax treaties is that essentially you don't have to apply Article 7, so the business profits, but you have to look essentially at these as sort of dividends that have not been distributed. So you basically would apply Article 10, but this type of logic applied to the operation of the IRR doesn't seem, let's say, it seems arduous to transpose this very logic to the working of the IIR, for instance. So also on the technical plane, there are, I think, good reasons to doubt of this analogy, which again, I would like to stress again that, of course, this compatibility, I think, is now less controversial, but not completely uncontroversial compared to some years ago.
I see. No, IIR is it's the IIR discussion in general is very controversial, but I'd like to move to another method which is also controversial. At least it's a very revolutionary in some sense, which is the UTPR, and I believe it's one of the strongest points you have in your chapter is the argument that UTPR, at least in its current design, is unprecedented and breaks with the long-standing principles of international tax law, including economical agency and the nexus rules. Having said that, could you elaborate a little bit more on why the UTPR really represents a conceptual rupture with this tradition in the international tax field, and how these affects the interaction with the tax treaties?
Yeah, thank you again. Very interesting question that would deserve maybe a dedicated talk. And I would say it's a lot has been written on the UTPR, and I would say that if you look at the literature, most of the contributions are in fact on the relationship between the UTPR and tax treaties. So whatever we said, let's say, again, to use another Latin broker, in dubio pro reo, so maybe with the IIR we can give the benefit of the doubt. In the case of the UTPR, the friction seems always a little, let's say, somewhat more evident. And again, I would like to, let's say, a fortiori, for instance, you cannot apply there the kind of rationale that we saw in connection with the assessment of the compatibility between CFC rules and tax treaties, because at least in CFC rules you have this chain of participation, of control, sort of vertical chain that allows, let's say, to some extent to make this argument more viable. In the case of the UTPR, this chain is simply not present, because it could be any essentially entity within the group almost that needs to charge the tax. So it's a type of extraterritoriality. Of course, also CFC legislation and IIR also entail some form of extraterritorial taxation, but it's an extraterritoriality, I would say, that we are not quite used to deal with. Then, of course, this is a very charged area and topic. I think even in the literature you can find UTPR enthusiasts and UTPR skeptics. For sure, it's an intriguing development because it's simply so much unheard of. And another question that I think is legitimate, because of course, I mean, we bypassed a very fundamental question. I omitted at least a very fundamental question. When addressing the issue of the compatibility between globe rules and tax treaties, because of course the first question that you always have to ask is, okay, what is the subjective scope of application of a rule? So essentially, let's say, what about Article 1? And I would say there that even though we are not really dealing with residents, let's say with persons who are necessarily resident, we use more the expression location or located or localized is not a big issue. The second question is, are we talking about taxes that are covered, that are included in the scope of application of tax treaties? And I would say, in a way, of course, these backup taxes feed on, let's say, the same base as income taxes. No, so in the case of the IIR, I would say it seems, let's say, reasonable to conclude this is the case. The UTPR, of course, is just a backstop, no, to the IIR, so the same conclusion should extend also to the UTPR. But the way it applies perhaps also makes it closer, rather than to a tax, to a form of sanction or, in any case, countermeasure, no, for another jurisdiction not applying a certain, in this case, I was about to say a certain international rule. And of course, this raises another series of questions. What is the legal basis, no, of these globe rules? Of course, these are going to be adopted by countries in their domestic law, but how should we regard this common approach that is expressed in the model rules? Are we dealing with some sort of new type of source under public international law, source of law, or if that's not the case, of course, then we go back to the old issue of the interaction between domestic rules and treaty rules. And so essentially, how can we frame in the usual conceptual categories, this friction that we have addressed within essentially the framework of the, let's say, tax treaty override. And then, of course, it depends on the country. You know, some countries have, let's say, bows to their, let's say, a little bit more freedom in the sense. Other countries are, of course, in a different situation. But I would say the UTPR is essentially very, very problematic because of this lack of chain relationship that we observe in the IIR, because of, let's say, the kind of unforeseeable extraterritorial effects it may have, and because it has this, I would say, quite troubling the sanctionatory dimension.
I see. No, we of course we will not stop this debate right now. We still have so many issues to discuss on this subject. But unfortunately, I'd like to move toward the aspects of your article. You've also touched the saving clause and treaty modification, and I would like to stress a little bit this issue. In your article, you discuss the saving clause added in Article 1, Paragraph 3 of the OECD Model Tax Convention, and consider whether it could shield Pillar 2 from treaty conflicts. My question is, to what extent, if at all, can this saving clause address compatibility issues, and or do we ultimately need treaty modification, possibly even with a new MLI, a new multilateral instrument that has been used so frequently by the OECD?
Well, again, I hinted at the saving clause before, because I find that indeed, and in this case, maybe we can reintroduce the analogy, but there are, let's say, many authors that question whether the kind of, let's say, question what are the boundaries of the saving clause. Is it a sort of blank check for the country that applies certain rules, in this case, the globe rules, to do whatever it wishes? And I would say, of course, the answer is no, but there will be, I think, on balance, we could foresee that the saving clause in itself could be applied to sort of neutralize the potential frictions between globe rules and treaty rules. There are, in fact, however, some, let's say, gaps in the saving clause. So the saving clause, at least as it's contemplated in the OECD model since 2017, does not extend to the whole of the treaty, but leaves out, as contemplates, certain exceptions. I think I've mentioned Article 9, Paragraph 2, but a very notable exception is the methods article. So essentially the provision dealing with the elimination of double taxation, so exemption or credit. And another, and that's a very, I would say, call it a Pandora's box of issues is non-discrimination, so Article 24. So of course, whenever you have frictions that deal to some extent with some of these provisions, then we are left, let's say, without a safety net, so to say. So that's very significant. And of course, in particular among these, I would say Article 23, for the reasons that we mentioned before, could be particularly problematic, especially because a potential instance of friction may arise if we use, let's say, as a case study, Article 7, as we did at the onset, no? In those situations where the head office state adopts, let's say, the exemption method, then clearly this creates most likely a friction between how GLOBE rules operate and the terms of the tax treaty. And because, as we said, the saving clause does not cover Article 23, the method article. So of course, this conflict is there for us to. Then I know, well, it's in Brazil it's a big issue. Also in the tax treaty practice, I guess the application essentially of let's say different variations of the credit method, most notably the tax-sparing credit. And so the tax-sparing credit, I think quite intuitively would be difficult to reconcile, no, with the operation of GLOBE rules. So whenever you have a tax-sparing credit clause in your treaty, in the absence of, well, even if there is a saving clause, but because we said it wouldn't be covered. But in any case, this would also be an area that would be quite problematic. And with regard to non-discrimination, that's extremely, whenever I find always non-discrimination analysis extremely impalpable to some extent, and also because they imply a lot of a lot of counterfactual thinking, no? And I would say that also based on review of literature, most authors focus, for instance, on the possible frictions with ownership discrimination. And in this regard, there is no, I would say, consensus, but if someone succeeds in bringing this issue, personally, my take is that it would seem to me more of a sort of indirect form of discrimination that typically is not covered, let's say, under the non-discrimination clause under tax treaties, under Article 24. So I'm a bit doubtful whether this could fly. But if, let's say, a dispute under these terms is brought, then definitely it will be again a situation without a safety net, because the saving clause would not cover it. But this, we are working under the assumption that the saving clause is to be found in each and every tax treaty. And again, the tax treaty network may look significantly different from the, let's say, what is found in the OECD model. So many treaties, in fact, I would say, considerable portion simply do not include any saving clause. And of course, even if the saving clause could, as we said, provide a sort of extra layer of security, the fact that it's not there may sort of ignite potential conflicts, potential friction that could otherwise be solved under the very saving clause. So that's also an element to consider. I would say more of a quantitative, factual consideration, but that needs to be taken into account.
I see. Professor, that's a really fascinating subject. We could spend all day long on this discussion, but unfortunately we have to finish our program. But I would not like to close our episode without a final question concerning a message to policymakers and practitioners. For these actors like myself as a policymaker, an academic, and all the practitioners watching us today, what message would you leave regarding the importance of understanding the treaty implications of the global minimum tax?
Thank you. Well, it's if I can have, since there are let's say, well, 2 rules plus, of course, we consider maybe the QDMTT also in the picture. So maybe I will dwell on 3 points that come to my mind. So one concerns, as we mentioned, the policy landscape. So of course, the elephant in the room is that now we'll have to see what the side-by-side approach framework operates in practice. Of course, the fact that the US, let's say, have clearly distanced themselves, but personally, I don't find it too troubling. So in a way, the assumption was always that the US would be, let's say, somehow out of the system, because of course they have their own mechanisms, let's say, already in application. So maybe this could, a bit paradoxically perhaps, but serve as a sort of catalyzer for the other countries to revisit globe also in light of this potential friction, and perhaps conclude a multilateral treaty that could take care of the issues that we discussed. I think this would be the most principled approach. There are, of course, other alternative avenues to deal with this potential friction, one of which is, for instance, reliance on domestic legislation in a sort of mirroring legislation. Very, I would say, also elegant solution proposed in scholarship by Professor Danon, Gutman, Maísta, and Martin Jimenez, in light also of previous treaty practice in other, not treaty practice, but let's say domestic practices in other areas, especially in situations that involve countries, let's say, with peculiar situations. The other approach could be to simply include a clause, a sort of safeguard clause, we could call it, within treaties. And for instance, that's something that countries like Belgium and the Netherlands have done. There, the question is a bit, let's say, the situation is a bit clearer, and it could have been otherwise because of how, let's say, EU law operates. But they made the point very clearly that essentially globe rules would basically prevail over treaty rules. So that would be, I think, a sort of second best solution, to have a sort of saving clause that clarifies, let's say, the interaction of different planes. And if not, if nothing happens, of course, there is ample opportunity for testing these matters before national courts, most likely, as unfortunately another area that will be very interesting to discuss, but that I think that the time now is running out. But would be, what are the remedies available for taxpayers if they want to essentially have these potential frictions considered by, and of course you have domestic courts, and we could have sort of a Schneider case too, or maybe on the IIR. But on the other hand, if you look at the mostly administrative remedies available under tax treaties, it would seem that not a lot is available. So maybe now in the latest version of article of the OECD model from last week, basically the article 25 was revisited. It would be interesting to maybe incorporate something also on these specific issues, some sort of coordination measure with globe rules. Some countries, my country of origin, Italy, has done something, let's say, to that effect, trying to make the interpretive map available, let's say, activable by taxpayers in domestic legislation when implementing the Pillar 2 Global Minimum Taxation Directive, but that's the only example I'm aware of. So there is a lot that remains to be done, I would say, especially in the area of dispute prevention and resolution.
I see, Professor. Dr. Turina, thank you very much indeed for your insights, for sharing your experience with us today. It has been a real pleasure to learn from your work, to explore your article and all your research. I also wish you a happy birthday. It's a very special day, and thanks so much for spending your birthday with us today within the ESTB. And so thank you so much, and well, grazie mille.
Thank you.
And I'd like to extend our gratitude to the IBFD, which has authorized Professor Turina to stay with us today. And going back to our audience, thank you so much for joining us today. Please remember to like this video, to subscribe to the channel, and to activate notifications so you don't miss the next episode of the ESTB interview, which will take place in 2 weeks. As I always mention, some episodes are in Portuguese, others are in English, and we are considering to add some subtitles to the videos. But in the meantime, you can always rely on the YouTube's automatic captions. They work very well, but they are available only 2 days after the release of the video. And especially for our international audience, I highly recommend revisiting our previous episodes. Even though many of them are very Brazil-oriented, they explore issues of global interest, mainly the Brazilian consumption tax reform, which has significant implications for multinational enterprises and mainly for comparative tax policy debates. So as I mentioned, our next episode will be in a couple of weeks. I hope to see you all then. So until next time, bye-bye.